Good afternoon. We're very pleased to welcome our panel of witnesses here today to examine a very important, salient question of labor law. We're also pleased that the citizens and others who are here to join us today are here. I especially want to make mention to many members of the nursing profession who are with us this afternoon. I know this is National Nurses Week. We think every week should be Nurses Week. I think that's true on both sides of the aisle. We both have great respect for the work done by the men and women of the nursing profession. The topic of today's hearing is what I would call a Bermuda Triangle for workers' rights in our country. It has long been established under the National Labor Relations Act and its cousin statutes that there is a group of people who are entitled to the protections of the National Labor Relations Act that can be in a bargaining unit, that can be represented at the bargaining table, that can have the rights won in the contract. And then there's another group of people who are part of the management, who are supervisors, for whose divided loyalties would never make it possible to be in both a union and representing the employer. And for a very long time, although the definitions of those terms were not without controversy and ambiguity, for a very long time there was an understanding as to who was where in those definitions. In response to a decision of the United States Supreme Court, commonly known as Kentucky River, last September the National Labor Relations Board issued a trilogy of decisions which have become to be known as the Kentucky River decisions, which I believe make a substantial change in settled law in the country, and an unwise and unwelcome one in my view. I believe that these decisions, when practiced in the workplace and the marketplace to their fullest extent, something that frankly could not have happened at this very early time since the decisions are only from September on, I believe that these decisions unfortunately create a third category of American worker who has the worst of all worlds, that he or she has all of the burdens of being a rank-and-file employee, has essentially no say in who gets hired or fired, no say in how compensation is structured, no say in how the organization is run. So he or she has all of those burdens, but frankly none of the benefits of being in the managerial category. And by the same token, the person does not have the rights of being regarded as a rank-and-file worker, doesn't have the right to be in the bargaining unit, doesn't have the right to bargain collectively, doesn't have the right to avail him or herself of a grievance process that a contract may create. So we've created this Bermuda Triangle, in my view, where workers' rights disappear, never to be heard from again. Working with Senator Dodd in the less significant body of the Capitol, a number of us have come up with a legislative proposal to remedy that situation, which we believe would provide clarity to employers, fairness to employees, and predictability to the economy. Clearly, this will not be an uncontroversial proposition. We've assembled a group of witnesses today that will have some disagreements among the four of them. But I believe strongly that the decisions that were rendered in September of 2006 are misguided. And I believe it is both the opportunity and the obligation of the Congress to remedy those decisions so that we can restore fairness and predictability in this area.